Why would I need a power of attorney? And what should I do if I want to appoint one?
SALRI's latest reference is topical and one that has relevance for the lives of many South Australians. It's about investigating whether the current laws that apply to enduring powers of attorney are effective and are working as intended. These laws are contained in a South Australian law called the Powers of Attorney and Agency Act. Many often confuse powers of attorney with advance care directives. These documents serve different purposes. An advance care directive is a legal document which gives authority to a person to make medical decisions for someone else, usually an elderly family member, when they are no longer able to make these decisions themselves. In contrast, an enduring power of attorney gives authority to a person to make financial decisions for someone else when they are no longer able to make these decisions themselves. So, advance care directives deal with medical decisions and powers of attorney deal with financial decisions. In SALRI's reference, we're only concerned with powers of attorney. Enduring powers of attorney allow individuals, known as principals, to plan for their future by identifying clear legal arrangements for their financial affairs, which will take effect at the point that they lose their decision-making capacity. Powers of attorney enable principals to choose to appoint a trusted person, called an attorney, before they lose their decision-making capacity. In this way, powers of attorney provide a way for individuals to control their financial future. Enduring powers of attorney apply specifically to management of finances, property and other assets. While originally designed with good intentions in mind, instances arise where the principal lacks decision-making capacity and the attorney abuses their role to receive an early inheritance, or might misuse the principal's funds. Examples include draining bank accounts or transferring the family home into the attorney's own name. In most cases, the principal will not have the ability to monitor their attorney's actions, and even if they are able to, it's unlikely they will report the abuse given their position of vulnerability. The principal will often be socially isolated and highly dependent on those around them. The effect of this form of financial abuse on a principal can be a permanent and life-threatening setback.
What is a power of attorney? And why the fancy name?
Powers of attorney in South Australia are governed by the Powers of Attorney and Agency Act 1984. They are designed to make individuals who may be suffering from cognitive or physical decline more autonomous by allowing them to appoint someone they trust to make financial decisions in their best interests. In South Australia, a power of attorney document can only be related to financial matters. It cannot be used to make lifestyle choices or medical decisions for someone else. However, it is often the case that making a financial decision can have a lifestyle or medical effect. For example, the payment of the cost for nursing home or payment for medical costs. Powers of attorney can also be enduring and general. A general power of attorney may be for a specific period or for a certain purpose. The main difference between a general power of attorney and an enduring power of attorney is that an enduring power of attorney will continue to operate once the person who appointed the attorney loses capacity and can no longer make decisions for themselves. This can even include a decision to revoke the appointment, but in South Australia, the law is quite general, so there is wider scope on what you may wish to include. A power of attorney does not impact on a person's testamentary will and will cease to operate once a person dies.
What is capacity? And how do I know if I have it?
Legal capacity means a person is capable of making financial decisions. This assessment is different to what may take place in other legal contexts or in a medical setting. An enduring power of attorney is most commonly activated once someone has become legally incapacitated. This can create a number of issues around the assessment of capacity. It also means the person who appointed the attorney cannot revoke it, leaving them vulnerable to abuse. Capacity can have significant human rights implications if a person's freedom is wrongly deprived because they have been considered to have lacked capacity even though this was not the case. For this reason, capacity can be assessed by lawyers or medical professionals. Sometimes it can be hard to know if someone has capacity because this can fluctuate. For example, a person with dementia may have periods where they are lucid and have capacity, followed by periods of incapacity whereby they are unable to make financial decisions. A lack of capacity to make financial decisions does not mean that someone is unable to care for themselves or use money. It means they are unable to understand the nature and consequences of their decisions relating to their finances. If you disagree with a person's decisions about the use of their money, this does not mean the person lacks capacity. If that person understands the consequences of their decisions, they have capacity.
Why would I want my power of attorney to be registered?
There are no national requirements for the creation and management of powers of attorney, and these issues are dealt with on state and territory basis. Currently, there's no requirement to register powers of attorney in South Australia, although there are in some other states. In December 2019, it was announced that due to concerns about the abuse of powers of attorney, and particularly the role in financial abuse of the most vulnerable of Australians, that a national register would be established. This register, once functional, will allow people dealing with powers of attorney, such as legal representatives, banks and financial institutions, to ensure that they're valid and also to report any suspected breaches of an attorney's duties. There are considerable benefits to a national register. These include expediting the verification process, ensuring that a person's autonomy is protected by establishing their financial wishes, and the safekeeping of documents. There are also a number of issues with a national register. These include the costs associated with keeping it, potential privacy breaches, and also the difficulties that elderly Australians or those who are illiterate may have in accessing the material.
I need a power of attorney. How do I decide who to appoint?
An attorney is the person appointed to manage the financial affairs of another. In South Australia, an attorney is required to perform his or her duties with reasonable diligence to protect the interests of the principal. There is very little guidance in the legislation about this, although each power of attorney document can detail specific conditions, rules, and requirements for the attorney. As the attorney will make financial decisions for you in the event you cannot do so, it is important to choose someone you trust and provide them with guidance about your wishes and preferences when creating the power of attorney. Alternatively, the public trustee can be appointed as an independent body to take on this role. However, a fee is charged for this service. Attorneys do not make decisions about medical treatment, accommodation, or lifestyle, but they are responsible for funding these choices and need to be involved in this process. If an attorney does not act in the best interests of the person who appointed them, they may be responsible for any loss incurred. This may occur if the attorney's actions are deliberate or involved a failure to exercise reasonable diligence in their decision making. This responsibility arises because the attorney has accepted an obligation of undivided loyalty to the person who appointed them, thereby creating a fiduciary relationship. In exercising these duties, the attorney must act in good faith and keep the confidentiality of the person's financial affairs. Upon appointing an attorney, a person may disclose their preferences to other trusted people in their lives. For example, a person may inform close friends or family with respect to a sale of property.
If my attorney does something with which I do not agree, can I change it? And are my finances and property protected?
Under the Powers of Attorney and Agency Act, attorneys are given significant scope to make virtually any financial decision that they see fit. This can be restricted to specific documents appointing attorneys if a person wishes. Powers of attorney can be left open to abuse, whether that be intentional or unintentional. Instances where attorneys have abused their role to receive an early inheritance or otherwise misusing the principal's funds with or without malicious intent often occurs where the attorney is aware that the principal lacks capacity or the ability to monitor their actions, and that can have permanent life-threatening impact. However, when this occurs, there are actually limited options to remedy the abuse.
There are various civil and criminal law remedies that exist to deal with the misuse and abuse of powers of attorney. However, in practice, these remedies may well prove ineffective. The victim may sadly have died before the abuse ever comes to light. Alternatively, the victim may be unwilling or unable to testify, or unable or unwilling to make or pursue any complaint. Formal civil action is costly and time-consuming, and the problem of relying on the criminal law is the police may not wish to get involved and treat it as a purely civil matter.
The Powers of Attorney and Agency Act allows for the Supreme Court of South Australia to remove the power of attorney, or for the South Australian Civil and Administrative Tribunal to appoint an independent administrator where it is found or suspected that an attorney has acted inappropriately. Where an attorney has acted inappropriately or has failed in their duty, the principal can apply for compensation for any loss that's associated with that failure or action. The Powers of Attorney and Agency Act also makes it an offence for an attorney to fail to keep accurate records, with a failure to do so resulting potentially in a fine. So a number of practical measures could be taken to prevent abuse before it even happens, and these include things like increasing community awareness of the roles of powers of attorney, ensuring that the principal and the attorney have signed the document with full knowledge of their rights and obligations, only allowing the use of powers of attorney where the appropriate conditions have been met, notifying others of the appointed attorney, ensuring that powers of attorney include statements of wishes which are well known in regard to the management of financial affairs and payment for medical treatments, and finally providing copies of the enduring power of attorney to others, including financial institutions and legal representatives.
Hello, I'm John Williams and I'm the Director of the South Australian Law Reform Institute, SALRI. South Australia, well before Federation in 1901, had developed a strong tradition of law reform and can claim a number of firsts over the decade as it shaped the law to the needs of our community. SALRI was established in December 2010 under an agreement between the Attorney-General of South Australia, the University of Adelaide and the Law Society of South Australia. It is based at the Adelaide Law School. We are an independent law reform body which conducts inquiries, also known as references, into the law. The areas of law are determined by the SALRI Advisory Board and sometimes at the request of the Attorney-General of South Australia. When we undertake its work, SALRI has a number of objectives, and these include asking how the law is working in a particular area at the moment. What are the comparative experiences in other places? We identify law reform options that would modernise the law, that would fix problems in the law. We consolidate areas of overlapping parts of the law and remove unnecessary laws. And where desirable, we try and bring South Australian law into line with the other states and territories. In undertaking this research, we attempt through various means to consult widely with experts in the area under review, as well as the general public. The experience law in action is something we always are interested in during our consultations. I am fortunate to lead a small group of researchers who, with our law reform students, have undertaken a number of major reviews and reports. I thank you for your interest in this reference and the Institute. Please feel free to contribute to our work via our website and our email that now appears on the screen. Thank you.